Good evening, my fellow Americans. My name is Pete Sidlaka, and I'm a bar and restaurant owner from Buffalo, New York. And I'm here today to ask you to get these monies back from these people. $100,000 from Scott and Barry Weinstein and $11,000 from John Ring. These monies that were illegally taken from me by a law called estoppel. Before I go any further, I'm going to read to you the law of estoppel. Estoppel. An estoppel that arises when one makes a statement or admission that induces another person to believe something that results in the person's reasonable and detrimental reliance on the belief. A bar that prevents one from asserting a claim or right that contradicts what one has said or done before, or what has been legally established as true. Now, the reason that we have to bring this into light is because I was accused of breaking this law of estoppel for not disclosing a bankruptcy that I was supposedly put in. After inheriting a life insurance policy back in June of 2000, I decided to build a restaurant at Barry Weinstein's building. At the same time, I went to a lawyer here in Buffalo and asked him to sell a mortgage that I was holding to pay down some credit card bills. Now, the Supreme Court of the state of New York said in their ruling against me that the record established that Sidlaka was the sole shareholder and principal of Pacers, and that in connection with his personal bankruptcy proceeding, he failed to list his ownership of Pacers or his interest in the lease between Pacers and defendant as an asset or a debt in either proceedings. Well, the truth of the matter is that the filing was made on August 25th of 2000, and the contract was signed with Barry Weinstein on September 1st of 2000. So there was no asset to list at the time of this mistaken filing. So I began building the building in September of 2000 and went into business on February 1st of 2001. After I ran out of funds due to the fact that my change was not given back to me from the bills that I paid in my bankruptcy, money was kept from me for 18 months by the bank trustee, John Ring. Earlier on in the story, after I found out I was put into a bankruptcy on October 16th of 2000, I told him to stop and was told that it was impossible, that this could not be done. I had to turn over $270,000 to pay $120,000 worth of credit card bills. Now, I went to the UB Law Library and found out this mistaken filing clause that could have been applicated in my circumstances. It's under mistaken filing, chapter 58 in the bankruptcy book, where the debtor was not incompetent at the time she filed her petition under this chapter, and in addition was represented by counsel. Debtor's reason for desiring dismissal of petition, specifically that she or he did not fully understand the effect of her bankruptcy filing, did not outweigh prejudice that would result to creditors if debtor's requests for dismissal were granted. Now, this here sounds to me as though my bankruptcy could have just been dismissed, but it wasn't, and we carried on. Now, even before the lockout of myself with my business, I went to the court in May of 2001 to Judge Kaplan to have him ask Mr. Ring to give me my change so I could carry on this business. And what I was told was, in his letter of opposition, that I have right here is that I make this affidavit of opposition to the debtor's motion of partial abandonment of bankruptcy estate. That at the meeting I requested Mr. Sidlaka and questioned Mr. Sidlaka and determined that he had a substantial unscheduled asset, mainly of the inheritance of approximately $400,000. It was $460,000. That I requested one half of the sum in the amount of $200,000 be transferred to my office in order to pay all creditors in full plus administrative expenses. Well, the check was for $270,000, not $200,000. That the debtor in this action has already received money for his personal benefit. I do not feel comfortable providing the debtor with any additional sums of money until this case is closed. As the court well is aware, the event that any priority claims are filed, these will need it to be paid in full. I am unable to determine the extent to which there is a possibility of priority claims in this matter. Well, I gave him all my bills, so there wasn't going to be any more claims. In the event additional funds are needed for any priority claims, I would need to recoup $35,000 from Mr. Sidlaka. Mr. Sidlaka plans to invest the funds in a bar and restaurant business, does not provide the trustee with any comfort level that monies will be available to priority creditors who may have filed. Well, first of all, I gave him all my bills, and the restaurant was already started and running. It wasn't just starting and I was just going to start building it. It was already done. So this particular letter to the court doesn't hold much water with me. Okay. Now, after I went to the court, then Mr. Ring's bankruptcy ledger, he states himself here that on November 13th of 2000 that I was an asset case. And I don't know how you can be an asset case and have a bankruptcy at one and the same time. So I filed a complaint with the American Bar Association on the lawyer that I hired to sell my mortgage to pay my debts and not put me in a bankruptcy. And here's his response to my complaint. In his subsequent complaint dated September 25th, 2001, he stated that it was his expectations that his debts would be paid from the sale of the note and mortgage. While this may have been partially true at the outset of the bankruptcy, the disclosure regarding the inheritance after filing obviously changed the nature of the administration of Mr. Sidlaka's case. Well, this is the whole thing right here. I could have paid my own bills with my $270,000 check. I didn't need him for that. I wanted him to sell my mortgage and pay down my bills, partially or otherwise. So he's just confirming exactly what I wanted to do for him in my complaint to the ABA. So now we're going to go on to what is called the claims distribution that Mr. Ring put out for me. Claims distribution. Now, as I said, I owed $120,000, but because of the length and time that he took to pay my credit card bills, there was an extra $20,000 that were added on in interest, and he kept $11,000 for himself, the money that I want you people to write him to and ask him to give me back right here. Because he doesn't deserve it, and he sure didn't earn it. It was stolen from me. Okay. Also, there's the other point that I might want to add here. This is all wrong also to the extent that I had to tell the New York State Liquor Authority where all my money was coming from before they even granted me a liquor license. So all this was disclosed, and everything that I told these people to do, they didn't do, and they just carried on with this bankruptcy till there was no end in sight. Again, I ask you to write these people, Scott and Barry Weinstein and John Ring, and ask them to give me my money back. $100,000 from Scott and Barry Weinstein, and $11,000 from John Ring. Thank you very much. And I'll be back to this site again if it's necessary. Thank you.